we've got a series of bills that have had hearings the last few days, so we will begin that process with the first bill being Representative Ballinger's House Bill 452. Ms. Ballinger, would you please come up and submit your bill to us? House Bill 452, which is LC 296361.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, the majority of the bill, it's a roughly a 3-page bill, but I will direct your attention. The pertinent parts are on the top, lines 26 through 30. Basically, it's just adding a pretrial release or sentencing order that prohibits contact to the temporary protective order registry.
All right. So these were people who are receiving protective orders as a result of domestic violence.
Domestic violence, rape, aggravated assault, that sort of thing. So if there's a no contact provision in the bond, as crazy as it sounds, in 2015, the victim actually has to carry around a paper copy of the bond.
Right.
This will add it to that online registry.
Any questions from members of the committee? Yes, sir. Mr. Jacobs.
Representative Ballinger, I assume foreign court is a defined term elsewhere.
Yes, it is.
In this code, and it means a court of a sister state.
Yes.
All right.
Any other questions? If none, we appreciate that. Do we have anyone in the audience who wishes to address the committee on House Bill 452?
I do have a number of people that are here. I don't think anybody wants to speak, though.
The Georgia Commission, you're welcome
the Georgia Commission and the Georgia Coalition Against Domestic Violence are both here in support, as is the Prosecuting Attorney's Council. So,
thank you for attending. All right, no further comments from the public. We will close off public comments, and the bill is now in the breast of the committee. Any discussion on the bill? If not, the chair will entertain a motion. Second. Yes, we do. 4.
It's 5.
It's 5?
Yes.
Oh, my mistake. We were waiting for a quorum then.
Oh.
My apologies. We are.
I will be at ease.
I thought it was 4, but it's 5. Okay.
Yeah, it's on the inside of the committee.
Yep. You're right. Error. Everybody, please stand at ease for a moment. We'll hopefully get somebody new in here. Another person rather than here. Where'd that note go? Let me mention while we're waiting, though, we do have a former member of our committee who's now serving as a judge of the Superior Court in Glenn County, Roger Lane. Mr. Judge Lane, glad to have you with us. Always a pleasure to see an old good friend come back. And we have District Attorney Hayward Altman. Glad to have you too. Thank you so much. I'll look at any other judges or DAs in our presence, or solicitors. So we'll see if you can find out. Susie, if we got somebody coming. All right, now we do have a quorum, and the chair will entertain a motion on House Bill 452. Has been moved and seconded. Any discussion on the motion? No discussion. Chair will call the question. You do favorable motion to House Bill 452 do pass. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. You are so welcome. I was going to call Mr. Mabra. Did you vote?
I like it that much.
That's right. You like that much.
Really like it.
Well, since you're the only other person here, I think we got Mr. Maber's not here, Mr. Fleming's here, but we're going to hear his probably last. And Mr. Reeves, you are next. If you'd like to come forward.
Thank you, Mr. Chairman. May it please the committee, and what I guess will be my last time before you guys this session, at least before crossover day.
I should announce we're going to be hearing what is House Bill 418 LC 296557S. And you can proceed.
Okay, thank you. I bring to you House Bill 418. I know a lot of you were in subcommittee yesterday and heard a lot of discussion on this. But this is basically a bill I have brought on behalf of the Prosecuting Attorneys Council to essentially expand the restrictions of who can serve on a grand jury to deal with a conflict of interest that exists for persons who are participants in or active participants in an alternative prosecution program and who are summoned to serve on a grand jury. We talked a lot yesterday in subcommittee. In general, there has been a large expansion of alternative prosecution court programs, such as pretrial diversion programs, accountability courts like drug court, veterans court, and mental health court, and also first offender treatments. And so as these programs grow, there's a larger number of participants in these programs, and thus the opportunity that someone may be selected to serve on a grand jury who's in one of these programs has become a problem. And so this legislation was filed in response to two specific issues, one that happened in Savannah and one that happened up at Blue Ridge in the Appalachia Circuit. And what this bill is seeking to do is it's seeking to make somebody who's an active participant in one of these programs ineligible to serve on a grand jury. If they successfully complete any of these programs, then and they're therefore not a convicted felon, then they would be eligible to serve on grand jury upon the completion of the programs. But while they're in these programs, we believe that it's a problem for two main reasons. Number one, a lot of participants do not complete or they fail out of these programs. And number two, there is an inherent conflict of interest in when you are in a diversion or accountability court, you report directly to an assistant district attorney who's running the program. You are under the direct oversight of the district attorney's office and of the court. And we believe there's a conflict of interest with simultaneously when you are under their oversight, serving on a grand jury where you hear hundreds and maybe even thousands of cases that will be presented, and you would be expressing a voice or an opinion on it. So we believe that these two conflicts of interest are important, and that because of that, we're asking that if someone's an active participant in these programs, that they not be allowed to serve on a grand jury while their participation is pending.
All right, thank you, sir. Is there any questions of members of the committee or the presenter? Yes, sir. Mr. Fleming.
Thank you, Representative, for bringing this bill. And the thing that I found, I guess, most telling or appropriate in subcommittee was when we discussed the fact that we have always had a prohibition against convicted felons serving on the grand jury. What has changed over time is that now we have all these diversion programs where we allow them in some instances to avoid that initial conviction in hopes that they straighten their life out and move on. And as I understand it, all you're doing is saying now that we have allowed these alternatives for them, until they complete that program, they'll be treated somewhat like the law, which has always been, is that someone under that problem doesn't serve on a grand jury until that problem, in this case, would be resolved. Is that basically accurate?
That's correct.
Okay, thank you.
Anything further? Yes, Ms. Evans, thank you.
Thank you, Mr. Chairman. Representative Reeves, I generally support the bill. I mean, it's a common sense measure in my opinion, but I have a question
Sure.
on the back side of the bill,
Yes.
lines 27 through 29. This is new, and so my question, two questions really. One is, before, the law right now is that if you, if there are ineligible individuals serving, which I guess would be subsections 1 and 2 currently, that is a reason to void the indictment, and now we're saying it's not. But is it, and then secondly, just generally speaking, with the additions of lines 27 through 29, is this at least a basis to challenge the indictment, even if it doesn't automatically quash it?
No, this would currently, and Mr. Spahos can correct me if I'm wrong here, but currently a convicted felon serving on a grand jury would be the basis to quash an indictment. And so we are looking to move away from that with the growing number of people participating in programs, especially other states, things like that. So we do the best we can. A jurisdiction does the best they can to identify when somebody is, what would be currently a convicted felon, or with this legislation in these types of programs. But it's essentially impossible when we can't control what another state reports on their criminal information center database, and that's essentially where we're pulling this information from. So if somebody were to be in a diversion program in another state and were served on a Georgia grand jury, if the state of Georgia was unable to find out that information, then we don't think it would be appropriate for an indictment to be quashed for that reason.
Come on up. Why don't you come up, if you would, Ms. Spahos? Let you also address the committee on this point.
Mr. Chairman, I also brought.
Pull your mic around.
Just for one.
Yeah.
If I could quickly, part of the problem is, as you all know, we vastly expanded the pool by which we draw jurors. When we did that, that opened up a situation that we've had to deal with, where the convicted felons and otherwise ineligible people are they're all in the pool that we draw from. So we use what tools we have to try to screen through that. But and DA Altman can talk to you a little bit about it. The problem we've had is sometimes, even though our records don't indicate that an individual is a convicted felon, for instance, somebody later determines that that individual was, and that's a way to come back and challenge an indictment. And we've had a whole grand jury's worth of indictments in some circuits set aside, and we have to go back because the grand jury wasn't honest with us and answered that question, and it didn't show up in GCIC that way. But somebody was able to go pull a record somewhere and challenge that grand jury when there's no actual prejudice shown in that case. So what this does is says we're going to continue to do as much as we can to keep these people off, but if they get on there and haven't otherwise interfered with the system, this technical aspect of it shouldn't set a charging instrument aside. So that's where we're at. And Hayward, you want to talk a little bit about your
Hayward Altman, I'm the District Attorney in the Middle Judicial Circuit. I'll give you two examples. I'll give you an example, a practical example in Candler County the other day, which is one of my counties. We sent out summons of 100 grand jurors. Because of the new list that we have, we only had 16 people show up off of that 100. One of those came up to us. Yeah, that is creating a problem in rural areas with that stuff, that we're running about 30 to 40% show up rate from summons sent out for Travis and for grand jurors. One of the individuals there came forward on his own and said that he had been in a program in Florida and was a first offender. It did not show up on our records anywhere. We started asking him whether or not he had successfully completed or not, and his answer was, I don't know. I mean, so you would figure he would know or whatever, but he did not know. So we had to delay that because we only had 16 people, and that's the minimum number of grand juries we had. We had to actually delay the grand jury process for 2 hours, basically an hour to an hour and a half to 2 hours, so we could determine whether or not he was a convicted felon, whether he had successfully completed that program or not. We were successful, and he had successfully completed it, so he was eligible to be on the grand jury, and we certainly didn't mind him being on the grand jury, but we couldn't put him on the grand jury until we actually knew. So this is the situation you come up with. The one I told the subcommittee yesterday, and I do appreciate the work that Representative Reeves has put into this program, into this bill, and what y'all talked about yesterday. In Jefferson County, we had one who we recognized as a convicted felon. We checked his record real quick because we had to run these records, It was determined that we could not find it on his record, but I knew him. Sorry about that. I knew him, so we went downstairs and pulled his record from downstairs and came back up, and he refused. He actually had served until we could actually do all that. We actually had to have him physically removed from the grand jury because he wanted to be on the grand jury, and we did physically remove him. The point behind most of the bill, though, is the sensitive nature that we're introducing into a grand jury through the evidence that we produce is evidence of things that we don't want someone actually going through this program if they do not successfully fulfill these programs, or if they don't fulfill their first offender, then something happens and they've got information that they should not have as a convicted felon. And so it's for protection of law enforcement officers and protection of the general public, that these people, until they successfully complete these programs, they should not be allowed to serve.
One follow-up, if I might,
Sure.
Mr. Chairman.
Go ahead, please, Ms. Evans.
Is there any, what would your opinion be of perhaps adding the word solely in front of the word as on line 28? So you couldn't quash an indictment solely as a result of such ineligibility, but it seems like if we're going to the trouble to say that these individuals are ineligible and they shouldn't be on a grand jury, but we don't have any consequence if they are, at least for the defendant to challenge the indictment because of someone serving who's ineligible, that seems problematic because that means there's no consequence at all for violating the law.
Well, but understand that part of the protection that we're trying to afford is the protection of the grand jury and the fact that oftentimes they're privy to, they hear evidence of ongoing investigations and other information about those cases. That's where we're trying to keep the individuals, quite frankly, that are currently living in the drug world and under one of these drug sentences from being in the grand jury room. So it's not so much that we're after trying to change the nature of who's returning the indictment, or is we're trying to protect the integrity of the grand jury itself. But what you've done then is you still give everybody the ability to challenge an indictment later when there's no other irregularity other than that individual was there. And here's another example of how that can happen. They're in a program in an adjacent county or an adjacent circuit. When they are put on the grand jury, you run it, you verify that everything is good to go. But if they were to get convicted or revoked during the time they're on a grand jury, that now they've become ineligible, it almost puts us in a situation now where you got to run the grand jurors every time they show up to hear cases to make sure nothing has changed, because if something changes and they don't notify us, then that indictment can be attacked, even though it didn't have anything to do with that indictment returning. So that's the problem we have right now. So that's one of the reasons that language is in there is if something changes, nobody catches it, but it doesn't hurt anything, then it shouldn't set an indictment aside.
What's the thought? What's the purpose behind now being able to challenge someone because they're ineligible, and what's the reasoning of the court? Because we're undoing all that with this bill.
Because of the way the statute has been written and interpreted. In fact, the fact that the court has looked at this and said, well, the way you wrote it, you said that these individuals are not allowed to be or are incompetent, and that incompetency has been interpreted to give you a challenge. And we're just saying, well, that's not what that meant to the extent of doing it. I'm sorry.
I'm sorry, I was thinking out loud. In your situation, if you have someone on a 16-person grand jury who was disqualified, and even though we had this language, what happens to that situation? You can't say that your 15 are going to be sufficient, could you?
At that point in time, we would have had to call off the jury. That's why we were so interested in finding out whether or not he could serve or not.
My point is,
subsequently, we had
my
somebody
point is, to make my question clear, if you had a 16-person jury, and you subsequently found out after this person had returned indictments
Correct.
that this one individual was not qualified, and of course you could remove him. I mean, you didn't have to. You say, well, Judge, the law says we didn't have to. It's not required that this indictment be set aside, but you still have the deficiency of not having 16-person grand jury.
That's correct.
So you still have the person removed on that basis, would
Yes.
you not?
Yes.
Or I'm not removed. The indictment's considered to be invalid.
That's correct.
Set aside. Okay. I wouldn't interrupt, but I want to try and find out more about that point.
Because this is narrowly drawn to a grand juror being ineligible to serve. You're talking about now you've decided the entire grand jury was invalid because you only had 15 people returning the indictment.
That's
You
a
could still
different
challenge that.
situation right there.
You could still challenge that.
Do I understand that and I didn't mean to interrupt you, were you through, Ms. Evans?
I have one other question. But
Go
I
ahead,
can wait.
please.
My only question, it's just isn't it true that we're setting up a situation where you could have one or more individuals serving on a grand jury who under subsection C2 are mentally incompetent, and then the defendant has no way to challenge that indictment against him or her?
That you could still challenge, as the chairman just said, if there were only 16 valid grand jurors in there, and that you could establish that one was mentally incompetent. Now you're attacking the grand jury. Under this series, what we're saying is, if there are, say there was 23, and was only 16 required, and one of them was incompetent, but there were a sufficient number of competent grand jurors that returned the indictment, you couldn't challenge it just because that one grand juror was invalid. You could invalidate an indictment where there weren't sufficient number of qualified grand jurors to return it. That is still possible under this provision, because this is about just taking out the grand juror, the one ineligible grand juror.
What's the subsection that would allow you to challenge the grand jury as opposed to an individual?
Well, I think the way we've worded this, we haven't precluded that.
Okay. All right. I'm finished, Mr. Chairman. Thank you.
Thank you. Mr. Welch.
Thank you, Mr. Chairman. A couple of questions. Just following from this point, the way I was hearing the chairman's question would be that if you don't have enough to serve on a grand jury, that could be challenged. So that's one challenge that could be raised.
Because that's a different part of that same code section.
But the way I'm reading this is that if the basis of the challenge is that someone was ineligible, so you'd have to establish that someone was ineligible. The way I'm reading subpart D is that you couldn't challenge it because someone was ineligible, and the only way you get to the challenge by the number of people being insufficient is by establishing that someone was ineligible. So I do think that it may reach further than we want the way it is written. So Representative Evans' suggestion of solely would cure that particular problem. And then the other question was, and this is more just kind of a practical question, how many folks are in these systems? What are we talking about in terms of diminishing the jury pool or the grand jury pool? Because I think there's a practical aspect of this. I'd like to know how big of a dent we're going to put into the prospective pool.
Well, understand now that the grand jury pool and the jury pool are the same pool. We eliminated the concept of a separate grand jury pool when we took the provisions out about they should be the upstanding members of the community, or whatever that language was that used to be in there. So this would eliminate, a small portion. We see it, but it's a bigger portion now than it used to be because of the expansion of these courts and the fact that so many more of the individuals that used to would end up convicted are going to these courts. But to give you a number on what population or what that represents, I don't know that I can do it.
And I couldn't give you that number. It's just a small number. But now understand, if they successfully complete the program itself, then they will go back into the pool itself. They're not being eliminated permanently. That once they successfully complete the accountability court program or the first offender or these others, then they would automatically go in there. So you'd have a constantly changing number. So it would stay the same as what you have now. It wouldn't really affect the sheer number just by a very small percentage.
Representative, I think that adding the word solely is fine. I don't think that
Yeah, we're going to look at that.
I think that would be a change that I would be fine with.
Anything further, Mr. Welch?
No.
Let me ask a follow-up question to where this discussion is going. Is what we're looking at as far as disqualification here, is it derived from case law and then was codified as a provision for why someone would become disqualified, or did we establish through statute this disqualification, or do you know?
My recollection is we have case law that has interpreted this statute to say because you have said they're ineligible that is a sufficient ground.
Okay, my point is, prior to the statute, if you had a challenge to a person on a grand jury who had been a convicted felon, was that case law developed and then we eventually put it into statute, or do you know?
I'd have to call Mr. Olson on that one.
Okay.
I had to yield to that
Just
one
curious.
too. I'm not sure about that. From my understanding, I've always dealt with it in statute. I do want to clarify one thing before I get in trouble back. I actually didn't go down and check the record. I sent my investigator down before my investigator tells me he's the actual one that went down and checked.
All right. Well, thank you, gentlemen. And I think we've got some others who want to speak to the bill, and I believe Ms. Sarah Michaels. Sarah Michaels. Sandra, I'm sorry. I should know that. I know that. I know
I
you.
know you do.
Excuse me.
Thank you.
Par-
Sorry about
my
my
apologies.
handwriting.
My apologies.
That was mine. I wrote badly. Yes, I spoke yesterday, and
But you didn't speak to us.
no, to the subcommittee, yes, but this is the full committee.
Right.
And again, I'm Sandra Michaels with the Georgia Association of Criminal Defense Lawyers. And with respect to Representative Reeves, we do oppose this bill. First of all, 151240 has a clear, bright line rule that if a person is convicted of a felony or is incompetent cannot sit on the jury. We do not screen prospective grand jurors for bias, which is what basically I think the proponents of the bill want, because they feel that if someone is somehow in a program from the state that they're going to be biased against the state, which is sort of some of the description that was said yesterday. We respectfully disagree. The other argument could easily be made that if someone's getting a benefit from being in either a drug program or accountability court, or a pretrial diversion program, or first offender, which are listed under subsection 3, 4, 5, and 6, they would be equally in favor of the government because they're getting a benefit. So the theory that they have an inherent conflict of interest, I don't believe is really borne out by the facts. Another issue that was brought up is that these people, I'm not sure, because we're talking about people from all walks of life, these are non-violent offenders. These are people maybe with bad checks, forgery, shoplifting, trespassing. These are not all drug people, as was discussed. If the theory is, or the fear is, that someone is going to have access to information that's being presented to the grand jury that could somehow endanger an ongoing investigation, then maybe you should narrowly tailor this and say someone with a pending drug case should not be allowed to sit on drug grand juries. But why would you eliminate everyone in every program? The theory is that these are citizens that have gone astray and they just need to get a break and to be put back into the society again. Then why are we saying that they're not really eligible to sit on the grand jury? I just think the bill is sort of opening a can of worms. It's not a great idea. I think the Representative Evans' concerns about the ability of people to be challenge it is also an issue. One thing I have not been able to research, but it also raises to me, is if you're being charged with a crime is not sufficient to exclude you from the grand jury pool or the jury pool, then why is it someone that is actually still not been adjudicated guilty not eligible in a grand jury? I think this is going to be a problem. Also, the practical aspect of if they're in these programs, they're not going to be allowed to sit in the grand jury. What's going to be the mechanism to know that they've been allowed to be back in the grand jury? Because they're not actually technically taken out of the pool. It's going to be from the DA's office who's going to go run their GCIC, and how are we going to know whether they're good or not good to go? Again, I just think this is a bad idea, and we would respectfully request you not move this bill forward.
And we have a couple of questions, Ms.
Okay.
Michaels.
If I can answer my
Please.
Ms. McMichael, thank you for coming again today and talk to us. I was taking your suggestion in your comments that a practical way to resolve this may be to, when the drug conviction case comes up, to have the person in the drug rehabilitation program, leave the room and be excused. But let's think of the practicality of that. I mean, when you have the forgery case come up, okay, all forgers raise your hand, you have to go now. Okay, this is a drug case, all druggies, raise your hand, you have to go now. I mean, is that really a practical solution?
Well, I think, and perhaps I misunderstood what the district attorney said yesterday, was that basically they will run a GCIC on every single person. They're going to know what they're charged with. So if you really want to keep people in a drug program, again, they're nonviolent offenders, but that's really your worry, that a person is pending possession of marijuana charge, can't hear the information that's being presented, that's going to show on the GCIC that it's a drug case. So that would be very easy to resolve. That's a very practical way to resolve the issue that you raised yesterday, that you don't think people pending drug cases should sit on a drug grand jury.
Maybe I didn't understand your example. I thought you said when we get to the drug case, we have the people in the drug program lead the grand jury. Is that not what you suggested to us?
I don't believe that is what I said.
All right, how would it work then?
I think the way I just said, that the way it's going to work is the way they described it yesterday, the DA's office would run a GCIC on each prospective grand juror. That's how they do it. That's how they determine who's a felon and who's not a felon. And sometimes there's mistakes. Sometimes people slip through. And they can see from the GCIC whether they have pending charges or not. Because if they're in the drug program, it's either going to be open or closed. And someone has to do something to successfully complete it. We already know the problems with first offenders because they don't proactively go and close their case. So they're going to be alerted to what the charge is. So that seems a very easy way to resolve the issue.
But maybe I'm not following you, but I'm still trying to get to the practical way of this works. You just told me that's how they're going to identify who's got the drug problem and who's in the drug rehab program. How do you get that person out of the grand jury once you let them sit in there for the other cases, but now you've come to the drug cases?
Well, how are they going to do it now with letting all these people out?
They don't come into the grand jury for any cases under this situation.
But you're still going to have to look on the GCIC and see who has these cases, who's in these programs.
So you think it's okay when you get to the drug case to say, okay, Thomas, you're the drug rehab program, you leave now?
I don't think I'm following what you're saying.
How does your suggestion of how they solve this problem practically work when you've got a room full of grand jurors and one of them's got to go?
How are they going to get rid of these people anyway? They're going to have to.
They're not going to be there to start, so when they come to the drug case, they don't have to excuse them.
They can do the same thing. If somebody's in a drug program, they're going to know it from their GCIC and they won't be eligible. If someone has a pending drug, is that not what you? If someone has a pending
I'm obviously
drug
not making
You can't
myself
talk.
clear. I've done my best, though.
That's all right. I guess one of the things that, and I'll get to you in just a moment, Ms. Beskin, but for the fact that they are on for instance, a first offender, they've actually entered a plea. Have they not? I'm under law. My question is, a first offender actually enters a plea, but is subject to the rights of having that sentence removed as a result of completing the first offender. So they're in a guilty situation. Their guilt has been acknowledged by the person because they've entered it.
Yes, and that would be probably different than some, but
For some, I agree.
Right.
And all, the point is, the others might have been given the choice either to take this program or you will have to go to trial or be entering a plea, potentially. They wouldn't be doing the program if they felt they were innocent, would they?
A lot of people
Maybe
in the
do.
programs that
Okay.
because the alternative is jail. So
The perfect world was saying they've accepted responsibility for what they have done and they've been given an opportunity. We'll call it, perhaps.
Okay.
You don't agree, but I mean, that's what I see happening. And the reason for, let's say, the legislature enacting these provisions is say, let's give them a chance. Now, where they are admitting their guilt, they may saw this as another alternative way to prevent that from happening. But for the fact that they had this opportunity given to them, they would most likely be in a program in a position where they've been found guilty of a crime charged against them in most cases. Correct? Maybe, okay. Ms. Beskin.
We established yesterday, did we not, that a person does not have a constitutional right to serve as a grand juror. Is that correct?
that's correct.
And if you compare 151260, the qualifications for grand jurors, to 151240, which is disqualifications for trial jurors, the disqualifications track in that the same person is disqualified from serving as either if they've been convicted or if they are incompetent and have not had their civil rights restored. Yet, -60 has additional disqualifications. There's a residency requirement. You have to live there for 6 months. But also under Part B, anybody's disqualified from serving if they hold elective office or if they have held elective office within 2 years. So what I'm saying is there's a bigger pool of people who are disqualified from serving as grand jurors, and it doesn't necessarily impugn anything about that person other than we just need to get grand jurors here, and we need to make sure that the process is not such that we are having disqualified persons serve that we're later going to have to invalidate this result. That's
Is
an
that not-
observation, it's not a question.
Okay.
I guess
Argument.
my response of an observation back would be then, why do you need section D? I mean,
Well, that's back to Ms. Evans,
right, which is a
Representative Evans'
very
question.
good point.
Right.
Well, thank you, Ms. Michaels. Good to see you as always.
yes, thank you so much.
Anyone else wish to address the Committee on House Bill? I lost my number. 418. Got my bill over here. Excuse me. No, I gave it to you. If there's not, then we'll close all further public input. The bill is now in the breast of the committee. Do we have any discussion among members of the committee regarding the bill? If not, the chair will. We do have discussion, or you go for a motion?
Quick question.
All right.
In the committee, I know I came in a little late. If someone could just sort of explain to me, I guess, the issue that we're seeing with the grand jurors, because I know things have come up in the news about grand jury returning indictments or not, but it seems like the way the law is right now, it seems like there's not major issues that need to be addressed. And I just sort of wanted to say, I guess, what's the big issue that this bill is
Maybe
going
Ms.
to solve?
Beskin can respond to your question. She has a book.
I'm just trying to think back to the subcommittee testimony yesterday as well as today. There's just this understanding or impression that more and more people are going through diversion programs and never going through the true trial and conviction process. And it's not always true that where there's smoke, there's not always fire. But I think that there's a perception that many people in diversion programs, well, they're there for a reason, and perhaps they, going back to Representative Reeves' point that they might have a conflict of interest in the case, it's not just a conflict of the interest in the case. They may actually feel like they have an affinity with the district attorney and have to do whatever would be pleasing to the district attorney in order to ingratiate himself or herself with that person. So I think that it's a conflict that really runs both ways.
Might also, as a follow-up, is only while they are in that program, it's not a permanent disqualification. But if they've taken a opportunity, we'll call it, to go through a diversion program, or like, as I mentioned earlier, the first offender plea, where you've entered actually a guilty plea, but a right to have that removed, you complete a certain probationary program, then your name's cleared. But while you're in that program, you're considered disqualified if this bill were to pass.
Got it. Thank you.
Yes. Further discussion? If not, the chair will entertain a motion.
Do pass.
Second.
We have a motion do pass with a second. Do we have any amendments? Let me first, if I might, Ms. Evans, recognize Mr. Fleming for an amendment. It may be resolving the same thing. Let me hear what he's got to say, please.
Mr. Chairman, on line 28, after the word pursuant, and I've got two words here that have been mentioned there. If we put only or solely, this would make that subsection D apply only to the previous language in subsection C rather than totally.
I think we will leave it to Ms. Travis, who's come. I think the proper drafting, as she has in the past, used the term only.
Only? Okay. Well, then my amendment would be after the word pursuant on line 28 to insert the word only.
All right, we have that's offered as amendment. Do we have a second to the amendment? Do we have a second to Mr. Fleming's amendment?
I second.
We have a second. Any discussion on the amendment?
Mr. Chairman, as you and I were jotting up here, there was some mention of, I think by Ms. Evans, that we didn't want to take the disqualification past the language that we had in subsection C, which dealt specifically with these areas of disqualification. So when you place the word only there after pursuant, we're only going to limit someone's ability to challenge a grand jury indictment based upon the previous section there. For example, I think the idea was given that if someone was incompetent, that you still ought to be able to challenge the grand jury, or if there was not a sufficient number, what we're doing is hopefully leaving that in play and allowing the challenge or the ability to strike an indictment pursuant only to what's in subsection C.
Ms. Evans.
I don't. I'll pose this as a question to Representative Fleming. Can you tell me how this would actually still allow you to challenge someone for being mentally incompetent? Because subsection C is everything, including the old subsections 1 and 2. If to do what you're doing, I think you would have to say pursuant only to subsection C 3 through 6. But then you still don't have a way to challenge. I'm just not sure that this addresses the issue, and I'm not expressing it very well. But I don't think that it gets us where we're trying to go.
You're saying it should only be as to those things which are newly being added as a result of this bill today?
No, but I thought that's what Representative Fleming was trying to do. I think it would be better to put solely in front of the word as to take care of our issue. I don't think that this accomplishes what we've been discussing as the issue.
Can I ask,
Sure.
respond to that? What if we place the word only after the word quashed instead of after pursuant?
Yeah, that's what I would suggest. Only or solely.
All right. Well, I put him in that bad position. I'm suggesting that language. Sorry about that, Mr. Fleming.
No problem.
Who else had a question over here? Was that you, Mr. Jacobs?
Well, I don't want to belabor the amendment, but I don't see how that necessarily gets to your 16-person issue either.
It doesn't. It doesn't have to.
Right.
It doesn't have to. That would be a different means of challenging entirely from what we're talking about here. They have a different section or different laws that deal with that.
Well, I understand, but I think the placement of only or solely, personally, I prefer solely, but I think the placement of only or solely after quashed is clearer than the
Okay.
other placement. But we've already beat that one.
I agree.
And I agree. We'll leave it to the Scrivener, Ms. Travis, when she arrives, to decide which term to use. That be all right?
Sure.
I think the intent we have
Always
is,
defer to Ms. Travis.
Thank you. First Amendment will be withdrawn. Is that correct?
Yes, sir.
All right. And the second has also agreed to that.
Yes, sir.
And we'll have another amendment that will come from Ms. Evans. You want to propose yours, Ms. Evans?
Thank you, Mr. Chairman. I move that we amend the bill on line 28 to add the word either solely or only at the discretion of Ms. Travis in front of the word as.
All right. We have a motion to amend and a second. Any discussion on the amendment? If not, the chair will call for the question on the amendment. All in favor of the Evans amendment signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? If there are no further amendments, we're back to the main question, which is a due pass of LC 296557S as amended as committee substitute. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Motion carries. Mr. Mabry, you have a bill, I believe, next. You'd like to have House Bill 531, which is LC 296491ER. You can remain in your seat if you like,
Yes,
or you
thank you,
can,
Mr. Chairman.
the committee member will allow you to do that. You want to give us state your bill.
Thank you, Mr. Chairman. Members of the committee, I bring before you House Bill 531. This is a state bar bill. Bill simply expands Georgia long arm statute to the standard of international shoe that we've all learned about in first year of law school in Civ Pro civil procedure. Right now, our law stands as for long arm jurisdiction, to get personal jurisdiction, is that you have specific acts in the state of Georgia. We have a narrow standard for our long arm jurisdiction here in the state of Georgia by giving specific acts. The appellate courts, the Georgia Court of Appeals, and the Georgia Supreme Court has stated that we need to take our standard to a general type platform in which the Constitution of the state of Georgia and the Constitution of the United States would control personal jurisdiction. And that is given, the standard is given in international shoe, in which it says that one, you have to have, it's a two-pronged test. You have to have minimum contacts, one, with the state, and then second, you look at that it does not offend the notion of fair play and substantial justice. And that's basically resolves around the due process clause of the 14th Amendment. And this Bill 531 just takes our standard to a general standard in which we provide more protection to our citizens.
All right, thank you, sir. Any questions of members of the committee of Mr. Mabra? Yes, sir. Mr. Fleming?
Representative Mabra, as I understand it, this has been through the bar process and whatnot.
Yes, the State Bar Advisory Committee legislative agenda, they brought this to me, and I told them that I would carry it, and I did see the issues here in the statute that we currently have, and it's certainly a good bill. And not only the State Bar, but actually the appellate courts have been sending a message to us in their cases.
Right. Thank you.
Mr. Mabra, just one follow-up. What year did the international shoe case become decided?
1945.
Okay.
Any other questions, Professor?
That's all.
Yeah.
Don't catch him.
Don't ask me anything else about it.
Mr. Jacobs.
Just actually a statement. Other states have these long enumerated long-arm statutes, and then you look at the case law, and it'll say that the intent of the statute is to take our state standard to the full extent allowed under the due process clause of the Constitution, and I've always wondered why they didn't just say that in the statute. So I like that we have a statute that just simply says that, or we would have a statute that simply says that. I think it's a good approach, and I fully support it.
Thank you, Representative. And the question is?
It was I said it was a statement at the beginning.
That's right. I was waiting for a question. All right. Is there anything further of members of the committee of the presenter? If not, is there anyone else who would like to address the committee on House Bill 531? If not, we'll close off further public input. The bill is now in the rest of the committee. Do we have any discussion among committee members? If not, we will call for the question. The chair will entertain a motion. Motion is due pass, and it's been seconded. Any discussion on the motion? Any amendments? If not, we'll call the main question, which is a due pass motion to House Bill 531 as a committee substitute, I believe, or is it no changes? As a committee bill. All right. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. And next we have is House Bill 547, which is LC 296467 ER by Representative Fleming.
Thank you, Mr. Chairman. House Bill 547 attempts to straighten out a very likely unintended consequence for the what's been referred to as a widow's a year support, a unique law that we have in Georgia, which allows a widow or widower to apply to the probate court in the case of the spouse's death for basically something referred to as a year support. This unique Georgia law dates back to shortly after the Civil War, where many men had been killed in battle. Women were not allowed in many instances to own property. And when taxes were due, the widow was faced with losing her home. The probate courts are allowed to award a year's support for now the widow or widower in such circumstances. But something has evolved, and the Association of County Commissioners brought this bill to my attention, where on occasion, because of the way the law is currently written, it goes far beyond just the homestead, which is being protected. For example, if I passed away and my wife therefore gained the ownership interest in the building where my law practice is, and let's say I owned 1,000 more acres in a neighboring county, my widow could request that all those properties be placed into the year support request. And if that was granted, which quite often it would be, then all those properties would be protected from a year's worth of property taxes. Probably not the original intent of the law, the intent being to protect the homestead. So all this bill does is take back to the original intent of the law that the homestead will be protected from a year's worth of property taxes, not my law office, not other extra acreage that I may own. If I might, Mr. Chairman, ask Sean Adams with ACCG to come forward. He had Joe Schroyer over at ACCG, who is now their counsel, who used to be tax counsel here in the legislature, draw this up.
Yep.
You had a couple of questions yesterday in subcommittee, Mr. Chairman, about whether or not we should put the word unpaid property on line 11. I had a chance to speak with Mr. Adams, who had a chance to talk with Joe Schroyer about that, and that was legislative counsel, used to be cleanup language placed in there, and I'll let him elaborate on that if you would allow.
Sure, please do.
Thank you, Mr. Chairman. The reference on line 11 to unpaid property taxes, when I talked to Joe Schroyer, he basically offered that as a means of clarification. Spoke with him today. He said if there's more comfort in keeping that out of the bill to not provide any unrest to settled law, then he doesn't see any issue with that. And I would also reference the same on line 15 where it says paid or unpaid. That's a similar reference.
All right. I guess let me explain the reason I had that issue in my mind is reading that if I were the tax commissioner or the probate judge, the question may be, well, if you're filing this in January and February, you don't have any unpaid taxes until they're declared, which would be June or later in the year by the tax commissioners. I'm sorry, by the county commissioners, so, or even the city. So my concern was, will we be adding something here as another possible stumbling block in having that year's taxes set aside with the filing of the petition? That's why I looked at it that way. So, with that said, did you want to add anything further?
I'll just be available for any questions.
All right. Mr. Adams, anyone have any questions of Mr. Adams? If not, we're grateful for you coming, being with us today. Anything further, Mr. Fleming?
No, sir, Mr. Chairman.
Any questions of Mr. Fleming? All right. Anyone else in the audience wish to address the committee on House Bill 547? If not, we will close off further public comment, and the bill is now in the breast of the committee. And is there any discussion among the committee? If not, the chair will entertain a motion. Have a motion to do pass. Seconded. Do we have any amendments? The chair will offer an amendment, which is to line 11, where we have the underlying wording unpaid property, have that stricken. That would be the First Amendment. I'd offer as a Willard Amendment 1. Is there a second to it?
Second. It's
been seconded. Any discussion on the amendment? Now we'll call the question on the First Amendment. Oh, yes, sir. Excuse me, Mr. Well, pardon me.
Are we striking? We're striking the underlying language, unpaid property. We're striking both of those terms.
Yes, sir. The motion to amend is the striking of unpaid property on line 11. And that both words. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Chair will offer a second amendment, which is to line 15, where it states paid or unpaid, to have those three words as underlined stricken. It's been moved and seconded. Do we have any discussion on the amendment, the Willard Amendment number 2? If not, we'll call the question, which is to add the amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? Now we call the main question, which is a due pass to House Bill 547 as amended as a committee substitute. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Ms. Shaquille and Ms. Johnson, I should have said something earlier. We're going to hold up consideration today on. Did you enjoy being with us, though? I could have maybe saved you some time. I apologize. Hope you forgive me. But we're going to hold up consideration on House Bill 347 this date. And May 354. What did I say? Never mind. House Bill 354, which is the Fleming's bill. Thank you. Anything further will be mentioned to the committee. Reminder that we have a committee dinner this evening, which will be hosted by the Georgia Trial Lawyers Association. It starts at 6:30, and that'll be at the Legal Seafood, 275 Baker Street, Northwest Atlanta. And the parking is available in the Hilton Garden Inn parking garage. Do we have anything else further to come before the committee at this time? If not, the chair will call the meeting to adjournment. Thank you.